Thank you. Please be seated. We are here today in our case number CV190444, Kleinman et al. Versus Banner Health et al. Counsel, I think you both know, but please state your name and who you represent when you begin your remarks. And you each have 20 minutes. With that, let's start. Mr. Abney.
May it please the court, my name is David Abney. I'm here today representing the appellants. And if I may quote from a case, this is another one of those cases demonstrating the failure to understand the difference between contributory negligence and assumption of the risk, and the failure to appreciate the very limited nature of the defense of assumption of risk. That's straight out of the Hildebrand case on page 584. Oddly enough, as an aside, the five main cases that I was able to locate on assumption of the risk are all Division II cases. I don't know how that happened. One has a Division I number on it, and it was transferred down there for Division II to handle, so they're sort of
Are any of those, I'm sorry, counsel.
Oh, go ahead. That was just an aside.
Are any of those jury instruction cases?
Yes.
Whether to provide a jury instruction?
Well,
what's the standard?
Four of them concern the defense wanting the assumption of risk jury instruction, and the appellate courts and the trial court and appellate court saying no, you don't get that. The other one, the Hildebrand, is one of those cases where the instruction was given to the jury, and Division II said that was an error. That's the one that I quoted from.
And it shouldn't be given because there's no evidence in the record to support it. What's the test as articulated?
Well, the test is consent.
I'm saying to get a jury instruction.
Oh,
what is our standard of review?
There need to be evidence of consent. There would need to be evidence that the plaintiff understood the danger, appreciated the danger, and then voluntarily chose to confront the danger despite understanding it, appreciating it, knowing about it.
So generally that there's evidence in the record to support.
Right.
Okay.
And all five cases reached the same result in the end. And it's sort of boiled down in Hildebrand and other cases that you see, know, understand, appreciate. There has to be evidence that the plaintiff saw the danger, that the plaintiff knew the danger, that the plaintiff understood the danger, and that the plaintiff appreciated the danger. And then, of course, the final step is you voluntarily consent to confront the danger despite knowing all those things. And some of those cases are actually very strong. My favorite is probably the City of Tucson versus Holiday case, because when I moved to Tucson in 1967 and went downtown, I saw people crossing across the street diagonally. I'd never seen that before anywhere where I'd lived. And this is one of those cases. The woman was diagonally crossing a busy intersection in Tucson. There was a depressed area there. She knew about it, and she just walked in there. She got her wedge shoe stuck and got badly hurt. And the court said, well, sure, she understood that there was a problem there, but that's not enough. You have to have this actual consent. Consent is the key here.
But in that case, and in some of the others, wasn't it, and I've forgotten which case it is, but the electrocution one with the tree.
Gonzalez.
The issue is about how particular the understanding is of the risk. So like in that case, it wasn't just that he was electrocuted, it's that by touching the wire, which would have been a sort of a known or more appreciated risk, it was
right.
the sort of side risk. Same with crossing the street, wasn't it? That she knew of the depression, but
right.
not the particular hole or whatever that caught the heel. So
well,
the particularity.
It was the depression itself, something in that
Okay.
caught her shoe. So in each of these cases, there's a general understanding that there is something going on there.
So let's take it to your client's situation, and from his cross-examination, it seemed he had quite a deep history of understanding the particular risk, which is to say that from the time of medical school through the hundreds of operations onward, he was fully aware that there are these electrical cords and electrical boxes, and that he needed to be cautious.
He understood that there could be, and there often were, and that there could be electrical cords and electrical boxes. But he said, I just didn't see this. He said, I walked 2 or 3 steps into the operating theater, and down I went. And I didn't understand.
But is the test whether or not in order to get this instruction, is your suggestion that he would have to personally testify that he subjectively had knowledge of that box and that cord on that day, and that if he fell, he would break his knee? I mean, how
that would certainly be strong evidence.
Certainly, I'm guessing you wouldn't have had him testify to that either.
No, but just a general understanding of the danger, that's not enough. And that's, at most, that's what he would have understood. Generally, there could be a danger from cords and the power box. But this one, he didn't even know it was there. He testified. I just walked in and down I went.
Well, he testified that he knew it was in the room.
Somewhere.
His testimony, which didn't quite square with the other nurse's testimony, was as to the specific location
Correct.
of the cord and box. So he didn't know that it was in this unusual location, although if I'm reading the record correctly, he's the only one that testified it was in an unusual location. The others seem to indicate it was in a typical location.
And they weren't really aware, I believe, is a fair way to put it, exactly where
Okay.
it was. And the only reason he knew exactly where it was after the fact. When he's down on the floor, he looks over and says, oh, there it is. And it's in a place that he never expected. But you also have to get, I don't want to interrupt the question.
Well, I think, go ahead and finish your thought and then
All
I'll
right.
ask.
If you look at page 19, footnote 9 of the answering brief, you get a very interesting description of this danger by the defense. And the defense says, the record contains more than sufficient evidence to support the finding that the box/cord was not an unreasonably dangerous condition, but instead was a normal and necessary part of the OR working environment. So the defense is saying it really wasn't dangerous. So how is he supposed to appreciate the danger when the defense is saying it really wasn't dangerous at all? So this all goes to knowledge, see, as they say, see, know, understand, and appreciate. And, of course, consent. You've got to consent to confronting that danger.
Help me a little bit just so I understand what our standard of review is. I realize it's de novo on whether or not the instruction was correctly stated the law, but that's not really the issue here in this case. Is it de novo on whether there was sufficient evidence to support the giving the instruction? Because it seems that once there's been some evidence, we kind of would defer to the trial court on whether the evidence had reached a level sufficient to give it to the jury.
In general, I think the usual standards of use of discretion, and that's fine. But I think you're sort of stepping into a different arena when you're dealing with this assumption of the risk problem, because we have a wealth of case law in Arizona, and of course the restatement, that makes it clear that what you need to have is this seeing, knowing, understanding, appreciating, and consent. And we don't have that evidence to support giving the instruction.
But doesn't the restatement say consent can be implied from the circumstances?
It can be in certain cases, but fortunately, I've never had such a rich body of case law with so many different and interesting scenarios about what's going on. You've got the woman crossing the street.
Really quick, just to clarify a point, would you agree that the Arizona Supreme Court has relied on and thereby effectively adopted restatement second here? I mean, are we operating in a world where restatement second is our courts have adopted and relied on that?
Yes, in general, and especially this provision is quoted over and over in these 5 cases. The interesting thing is they're going a little bit beyond the restatement, I believe. They're saying that this is a matter, it's a very strictly limited defense. I think the restatement's a little bit looser on it than these 5 cases, but the body of law that's developed from that in different situations is very consistent, that you have to have all these aspects showing that there is a subjective understanding and appreciation of the danger and subjective consent, and that's just lacking here, and that takes us to a different level.
Is Hildebrand the only case, though, in Arizona where the court abused its discretion in giving the instruction?
Well, it's the only one where it came up that way. The other 4 cases came up with the defense wanting to change things and
saying they should have given the instruction, and the court
Right.
found there that you did not abuse
That's
your
correct.
discretion denying the
yeah,
instruction.
and Hildebrand is the one where actually you get a reversal because the instruction was improperly given. All interesting cases, parking a truck in the wrong place, doing the trimming somewhat near a power cord and not realizing that the power can be transmitted through branches. I mean, who would know that? But you'd know there's a danger of doing anything near a power line. So you had that situation. You had the gentleman on the motorcycle understanding that if he got in an accident, it could have a punctured tank and it could catch fire and with disastrous consequences. You had all these different situations. Plus, you have some of the statements in the cases. I think in Hildebrand, it talks about going to a baseball game and sitting in a place where you know it's not screened from balls, or getting on a dangerous horse, a horse you know is dangerous, and getting injured. Well, who do you have to blame for that? Or getting in a car where you know that the brakes are bad, and then have an accident and getting injured. Or the restatement, and actually Prosser and the restatement and others cite this example of running out or stepping out in the middle of the street into busy traffic. And you'd think, well, that's a classic assumption of risk. And they say, no, it's not. It's simply contributory negligence. You are acting without due care, which is really the difference here one of the differences between comparative fault and assumption of risk is one deals with undue care and the other is consent. You could be as careful as the Dickens, you consent to the danger and you get injured, you're stuck under assumption of risk. That defense is going to land on you like a ton of bricks. But if you're just negligent, and that's what at most this doctor was, he was negligent. Maybe he had a general understanding that power cords are there, that lines are there, power boxes are there. A general understanding, over and over the cases say, a general understanding is not enough. You've got to have some support for giving the instruction. That's why 5 different cases they said the instruction shouldn't be given. So
how would the instruction given here differ that much from the comparative fault instruction?
Oh,
because as I read the instruction, it seems like it says it would reduce the liability. It doesn't talk about it being an absolute bar to liability in the instruction.
Well, it is though. I mean, if you.
But I mean, what the jury was instructed doesn't purport to say a bar to liability.
Well, I know I've got that handy here somewhere. You must decide whether Banner Health has proved that Dr. Kleinman is at fault by assuming the risk of injury, and under all the circumstances of the case, whether any such fault should reduce plaintiff's full damages. And that's right. It's an odd.
So I get your argument that contributory negligence and assumption of risk are distinct, but this almost sounds like they actually gave him the comparative fault instruction.
It's an oddball instruction, and I'll certainly give you that. Because I've read this over time again. I can't figure out where the instruction exactly came from. But the import is the import by the title and this assumption of risk, and the overall instruction is that if you find assumption of risk, you can find for the defense and against the doctor because he has assumed the risk. I submit to you that jurors reading this.
When you say import, the words don't say that though. So I don't know where you get the import from. I mean, as a lawyer, my general thing is, assumption of risk means no recovery, but that's not. The jurors aren't lawyers, and they weren't told no recovery. They're just saying reduce the amount of damages to the extent you find that he assumed the risk.
Well, I think the meaning of this to the average juror would be if we find he assumed the risk, we can hold for Banner. We can reduce damages to 0 and just hold for Banner. And I think that's.
What's your support for that proposition?
Well, the language of the instruction, Arizona law,
which you just read to me, which doesn't say that. But.
Well, it's awfully close though. I mean, it's an assumption of risk, and if you go in the jury room, the jurors will say, "Well, we've got this assumption of risk."
If they went to law school, sure.
No, well,
wouldn't it be a better read to say that the jury took that into the jury room and said, "Okay, well, this one comes into play if we find some fault, and we have to." Because that's what the second line of the jury instruction is, that you can reduce the damages or that you can apportion the fault, that there's a move on the liability there. But up front, they found no liability, so there was no need to go. Isn't that maybe a better read of how this jury instruction would have applied?
Maybe, but then again, maybe not. And that's the problem. We don't know exactly what the jury did. I mean, if you're on the jury panel and you look at this, we've got this assumption of risk instruction. So if he assumes risks, we can say that it's all his fault and all the damages go away and we don't have to worry about it. We're done. So I acknowledge absolutely that this is not the way I would have drafted a jury instruction on assumption of risk, but it's enough in the ballpark that I think it supports the argument that we're making that if that if they did take this assumption of risk defense to heart, and if they did take this argument to heart, then they're done. Of course, you have to match this up with the arguments that were made at the trial and the way the evidence was presented, that, you know, if he's guilty because he assumed the risk. He's responsible because he assumed the risk. I think I'm at my stopping point, if I may.
Sure.
Sure.
Okay.
Thank you, Mr. Abney. Counsel.
Good morning, Your Honors. Eileen Gilbride for the defendants. With me at counsel table, our trial counsel, Mr. Pena and Mr. Krols. I actually only have 2 points to make. First, plaintiff has not argued that the instruction was an incorrect statement of the law. Counsel has conceded that here again today. What this means is that the jury was correctly instructed that they should not consider whether the plaintiff assumed any risk until and unless they found Banner at fault. And if they did find Banner at fault, only then should they find for plaintiff and then consider plaintiff's percentage of fault. That's point number 1. Point number 2, the jury found no liability. Banner was not at fault, so the jury never considered whether plaintiff assumed any risk, whether he was contributory negligent, or anything like that. They found no fault, stop. So the point is, those are my 2 points. So the point is, it doesn't matter whether the assumption of the risk instruction was correct or incorrect. It could not have made any difference whatsoever to the verdict.
How can you say that?
Because they didn't ever reach that issue. They only decided they're assumed to follow the instructions, and the instructions tell them, you first decide whether Banner was at fault. If you find Banner was not at fault, you fill out verdict form number 2. That's exactly what they did. They filled out verdict form number 2. If you find Banner was at fault, you fill out verdict form number 1, which says, we find Banner at fault. Now we consider plaintiff's conduct, whether he assumed the risk, whether he was comparatively at fault, and we go down and we fill in the number or the percentage for plaintiff's percentage of fault. If the jury, as counsel was suggesting, if the jury had done that and found Dr. Kleinman assumed the risk, they would have filled out verdict form number 1. We find Banner at fault, and we go down and find Dr. Kleinman 100% comparatively at fault. They didn't do that. They filled out verdict form number 2. Banner's not at fault. We don't consider Dr. Kleinman's conduct at all. Honestly, that's the beginning and ending of this case. That's why the verdict needs to be affirmed, because their only argument has to do with whether there was sufficient evidence for an instruction that the jury never even considered.
Do you have any cases, or help me with how the instruction given here is different than the instruction that was found to be improper in Hildegard?
The instructions,
Or Hildebrand, sorry.
The instruction in Hildebrand was, well, I'm not sure if it was Hildebrand. I think it was Ocotillo, or 1800 Ocotillo. When jury instructions are found to be incorrect statements of the law, they have said, if you find the plaintiff assume the risk, you must find for the defense. This instruction didn't say that. And they have said, again, that the jury instructions were correct. There was no error of law, and that the instructions here were a correct statement of the law. The only time assumption of the risk instructions have found to be incorrect statements of the law, they've told the jury, you must find for plaintiff if you find assumption of the risk. We can't do that with our Constitution, and just the Chavez case says it outright. We can't do that. That's why, in response to your question, Your Honor, yes, we've adopted the elements of the restatement but not that last part of the restatement that says you must find for the defendant. So we have not, and the Chavez case says that outright. That would be unconstitutional. Those are the cases, there's only 2 of them, that say those are incorrect statements of the law. And if the jury had been instructed that they must find for the defendant if they found assumption of the risk, maybe you could ask whether there was reversible error because, okay, they found for the defendant on liability, but they weren't instructed that in this case. And so we have to assume that they followed the instructions. The instructions told them, you don't even consider assumption of the risk until and unless you find Banner at fault, and they never got there. Now, if you want to go on and talk about the standard of review, both sides have said it's abuse of discretion. We're here on the denial of a new trial motion, which is clearly an abuse of discretion standard. Whether or not there was evidence to support the instruction, again, we don't have to go there. We think there was, but we don't even have to go there. We can go there if you're curious about it, but we really don't need to.
Why don't you talk about the evidence? We have a few minutes.
You want to talk about the evidence? Okay, go ahead. Because I know it's sort of the law nerd thing.
Well, so there's some place between general knowledge and the
Yes.
specific knowledge required. Tell me what are the specific elements of the evidence here that get you closer to that particularized knowledge and particularized appreciation of the risk?
So to the extent they're claiming that having cords all over the floor in the operating room is negligent and unsafe, and I believe their expert, Dr. Bakken, made those kinds of statements. Clearly, Dr. Kleinman admitted that he knew that. He knew that since medical school. He worked in this OR hundreds of times, and there's always cords on the floor in the operating room, and he went in there and went to work anyway every day, knowing that that was a risk. So to the extent they're saying that that was negligent or unsafe or unreasonably dangerous, he clearly admitted that.
What I understood Mr. Abney to be saying, though, is that while the doctor was aware that cords are generally in the room, he couldn't have been aware of the placement of this cord because it was unusual, and in any event didn't have a sufficient appreciation of the particular risk posed. Can you talk to me about what testimony or what record evidence
Right.
goes to that?
And he did not testify that he was aware that the cord was stretched across the double doors. If that's what they're claiming the risk was, there was no evidence that he knew the cord was misplaced. Of course, the jury found that it wasn't misplaced because they found for Banner. But if we're going on the allegations, on their allegations, their theory that the cord was stretched across the double doors, there's no evidence. He didn't testify, and there's no evidence that he knew it could be or was stretched across the double doors and in his path. Again, we don't need to go there, as I said before, but we're talking about the evidence. If the risk is we have cords in the OR and you have to step over them and you have to be careful, yes, he testified to that over and over again. He knew that. If the risk is a different risk of knowing that the cord was across the door, no, he didn't know that. But then again, the cord wasn't across the door because the jury found that. But if we go before the trial and not after to what the theory was, there isn't evidence of that. Any other questions? I'm happy to, I have plenty of time to answer them. No?
I don't think so.
All right,
Counsel.
then I won't waste your time.
I appreciate your argument.
Thank you.
May I have her time?
You got 5:36.
Oh, thank
Plenty
you.
of time.
Thank you, Your Honor. Your generosity is legendary. My colleague, my esteemed colleague across the aisle said that the, quote, "the jury found no liability," end quote. Well, yeah, but we don't know why. We don't know if
Well,
it's...
why don't we?
well,
Because I'll tell you, her argument and their argument in the brief that the way the verdict forms were structured supports the notion that they never got to the assumption of risk.
Why? If you get to the assumption of risk, then there's no liability. And I know the assumption of risk, of course, first of all, the instruction, we objected to any instruction on assumption of risk at all. But as far as the instruction itself, it tells the jury, if you apply the defensive assumption of risk, the court
But doesn't
will
the
later do
instruction
so and so.
doesn't the instruction say, first determine if there's fault. If there is no fault, enter jury verdict form number 1.
Well, it says that in one of the instructions, but
Right.
in different...
And then only if you find fault do you get to the second part, which is the assumption of risk.
Right. No, because they could have found fault because of, they thought that there was nothing negligent that Banner did, or they thought that Dr. Kleinman had assumed the risk, and therefore, why worry about anything other than that?
I don't think that's what the jury was instructed. And I think what you've read and what she read to us earlier supports that notion. So you're going to need to point me to specific where it says they can consider assumption of risk in determining whether there was fault.
But the instruction starts out that Banner Health claims that Dr. Kleinman is at fault because he assumed the risk of injury. Then it talks a little bit about
Before
that.
this, doesn't it say that the instructions tell the jurors first determine whether Banner was at fault and then determine whether there was assumption of risk?
And no, not exactly. It says you must decide whether Banner Health has proved that Jeff Kleinman is at fault by assuming the risk of injury.
No, I think it's before
And
this.
under all the circumstances of the case, whether any such fault should reduce plaintiff's full damages. So it's an A-B thing. First they decide, well, did he assume the risk of injury? And then you would deal with damages later. But the strange thing at the end of the instruction is that, again, if you apply the defensive assumption of risk, the court will later reduce plaintiff's full damages by the percentage of fault. But if they decide that he's just assumed the risk, then they're done. And they can say, well, it's 100% his fault. We don't need to do anything else. The instruction doesn't tell us to do anything else. And so once we decide that, the court's going to do something. Well, the court didn't do anything because the court never asked the jury, well, why did you come up with this particular verdict? I don't know. It's an unusual instruction. It's not the one I would give, but I would. And of course, they did oppose giving any instruction at all, which is the key point here. There shouldn't have been any kind of assumption of risk instruction in this case, because my viewpoint is, and my submission to the court is, it would confuse the jury into thinking, okay, we find he's assumed the risk. What do we need? Let's go home. Yeah, we're done.
You talked about the 5 cases that you rely on or
Yes,
point
Your
to. I think her argument and response is, well, those didn't say that the assumption of risk, giving assumption of risk instruction was proper. It was the manner in which the instruction was given.
No,
it was the form of the instruction that was proper, not the fact of the instruction. Is that accurate or not?
Unfortunately, in the cases themselves, they don't actually lay out what the instruction was that was given, as far as I could see by reading them in any of the cases. The problem was that in 4 of the cases, the defense had wanted it, and the trial judge said no, and that was affirmed. And then in the other case, Hildebrand, the instruction was given, which led it to a reversal.
Okay.
And the reason why is once you start talking with assumption of risk to people, and we talked about lay people, but even with lawyers, a lot of us don't understand what the difference is between comparative fault and assumption of the risk. I mean, one is simply you're negligent, you don't exercise due care, and the other is you consent to the risk of being injured. And it's night and day between the two of those things. That's the point of this case. And you get assumption of the risk in front of people that just say, well, assume the risk. Your automatic reaction is, well, he assumed the risk. We're done. Goodbye. We're out the door. There was a whole lot here about a lot of evidence about where the cord was, where proper placement was, standard of care, all these things, and you can just junk those and do what they did here.
Mr. Abney, I just want to get your response to, in the restatement second, comment D, I found the language fairly applicable. It says, one who has spent substantial time upon particular premises ordinarily would be found in fact to understand and appreciate the normal ordinary risks of those premises. such as the danger from moving trains in a railroad switching yard. Why couldn't that comment also say such as the dangers from electrical cords on the ground in an operating room?
Well, under the restatement itself and then under Arizona case law, there's far more going on than that to have the assumption of risk defense apply. You've got to see, you've got to understand, you've got to appreciate the danger, you've got to voluntarily consent to it. That's one factor to think about, that you've been in a place many times and you've seen things there, and maybe it filtered in a little bit. But you have to have all the factors there present. In case after case in Arizona, they've said no. Where you'd think, if you glance at it and don't think about it very much and don't delve into the case law, you think, well, of course, he assumed a risk. He knows the place. It's got to be far more than that. I'm done, unless there's any other questions. Thank you very much.
Thank you, Mr. Abney. Thank you both for your argument. We will take it under advisement, and with that, we are adjourned.
Mr. Abney, were you on the case the Supreme Court decided today?
Yeah, how did they decide?
I think you won.
Thank God. It happens. Thank you, Your Honor. The Indian case.
Yeah.